Good afternoon, good evening, everyone. I'm thankful to those who took time to join us on this beautiful spring afternoon in Washington. Thanks for being on your computers, hopefully on a porch or something nice like that on a nice day. We have a really exciting conversation with our whistleblower advocate and proud alumnus, Andrew Bakaj. My name is Matt Donovan. I'm the Assistant Director of Annual Giving and Alumni Relations at the Elliott School, and I myself am a 2017 alumnus, so definitely proud to have a good group of folks who I consider my peers here with us today. This conversation is one of several in our Meeting the Moment series, where we've featured alumni who stepped up to a challenge in the past year in their own unique way. They were featured in the Elliott School's annual report, which is visible online with short vignettes, and these conversations are a way to expand on their stories and learn about their experience. So through this conversation, you'll hear about the challenge that Andrew stepped up to as part of his work as an advocate for whistleblowers, how he got there, and how he played a role in the first impeachment hearing of Donald Trump and how that grew to capture national attention. This is one other event that we are having among this broad ecosystem of bicentennial events as GW celebrates its 200th year. So there are a number of other programmings happening throughout the year in recognition of this milestone, and all details can be found for those at bicentennial.gwu.edu. And before we jump into it, just a couple of housekeeping items for Zoom here. Note that questions are going to be welcome at the end of the discussion. Our speaker is going to answer as many as time will allow, and we're going to be using the Q&A feature on Zoom to field those. So at any point during the discussion, enter your question into the Q&A box. We'll try to get to as many as possible, and just note that only Maria, Andrew, and I can see the questions, but we do have them on our end, and the chat function has been disabled. And then also for anybody who needs it, we have closed captioning available for our events, which promotes accessibility to all audience members. You can turn those on or hide them in your individual viewer with the live transcript button at the bottom of your screen. So with that taken care of, it's my pleasure to introduce our moderator, Maria Hershey, who is a great friend of mine and a fellow class of 2017 member. Maria graduated from the Elliott School with her BA in International Affairs and Security Policy. After that, she worked in the international trade law space for about 2.5 years before jumping into law school. So she is now a JD candidate at Catholic University's Columbus School of Law. So I'm going to disappear now, and Maria, turn it over to you. Thanks very much for being here and doing this.
Yeah, thank you, Matt, for thinking of me to do this. I'm really excited to be a part of this event. So a little bit about our speaker today. Andrew Bakaj is a former intelligence officer and criminal investigator who brings a history of distinguished service to his work as an attorney. He has represented individuals in adverse security clearance actions, in whistleblower activities, equal employment opportunity matters, in addition to individuals and corporations and organizations who are also facing investigation. His background as a subject matter expert in whistleblower reprisal investigations makes him uniquely qualified to represent individuals who have experienced retaliatory action as a result of lawfully engaging in protected activity, which is also known as whistleblower reprisal. And he also has a unique experience having been a whistleblower himself. So named one of the 250 experts and advocates outside of the government who will be shaping the policy debates of the years to come by Washingtonian magazine, Andrew played a central role in the first impeachment trial of President Donald Trump, where he represented the anonymous whistleblower who first raised concerns of Trump's call with the Ukrainian president. Andrew graduated cum laude from the Elliott School with a BA in 2003 and obtained his JD from Syracuse University Law School. Andrew, I'm so excited you could join us today to share more about your work, and we're going to kick it off with a question, hoping that you can kind of give us the landscape as to what the whistleblower landscape looks like, what the legal landscape looks like. I know you worked for the Department of Defense and the CIA on shaping the legal framework for these protections. Can you describe the state of these protections as they stood prior to 2020 and the role you played in developing them?
Sure. Well, first of all, I just want to thank George Washington University, the Elliott School of International Affairs, and everyone here for having me on. It's truly an honor. I think what will be prudent to do is kind of give a general overview in terms of how whistleblower protections work just within the federal government. And I'm going to focus on federal employees, not the private sector, because that's primarily the space that I practice in. I represent federal employees, members of the intelligence community, DoD, government contractors, et cetera. So with respect to whistleblower protections, federal employees, when they believe that they've been retaliated against for properly and lawfully disclosing wrongdoing, have an avenue by filing a complaint with the Office of Special Counsel, OSC, and then litigating it before the Merit Systems Protection Board. But members of the intelligence community and those who have security clearances did not prior to 2012. So what happened was when I went and joined the Department of Defense Office of Inspector General, I developed the legal and investigative framework to protect whistleblowers with access to classified information, effectively expanding and creating those protections for members of the intelligence community and even those individuals outside of the intelligence community, but who hold a security clearance. Because a concern was that with respect to a security clearance, that it's an easy way to retaliate against somebody for properly and lawfully disclosing wrongdoing by targeting something that they required to have in order to hold a job, and that is a security clearance. So as a general overview, one of the things that we were doing within DoD was also educating and training employees about what lawful disclosures are. So if you're at DoD, for example, or the intelligence community, you can't just necessarily go out to the press and disclose something that you reasonably believe to be a violation of law, rule, or regulation, or fraud, waste, or abuse. So there are internal channels where you can make those disclosures. And the reason for that is a lot of times that information is classified, and you can't publicly disclose classified information because doing so can significantly harm or gravely harm national security. But at the same time, there may be something wrong internally, whether it's somebody or a company absconding with a lot of money, an intelligence issue with respect to collection. Perhaps it has happened, or the allegations of this have happened, where there is an issue of spying on American citizens. So there has to be a mechanism internally where people can disclose lawfully wrongdoing. So what I did was I developed those programs and procedures within DoD, and that became the model, the framework for what eventually would become Presidential Policy Directive 19, which President Obama signed in 2012. And that formally expanded those protections to members of the intelligence community and to those who hold security clearances. So basically, I created the beta and the model at DoD-IG for the Defense Department and the Defense Intelligence Community, like DIA and the National Security Agency, and then it was expanded government-wide. And that was signed right around the time frame where I joined the Central Intelligence Agency, Inspector General's office, and I was tasked to lean forward and effectively develop the regulations and the internal procedures to comply with a policy directive that the president had signed that was based on my work at DoD. So it was quite the ride. And one of the things that I just want to flag here is that, this is actually really important. For American citizens and the taxpayers, we want to have a mechanism for people to come forward and lawfully disclose something that they see wrong. If you see something, say something, as the phrase goes. But in order to encourage people to do that, you have to have a mechanism on the back end to protect them for doing so. And that's what I developed at DoD and CIA.
Yeah, I've heard that whistleblower protections are extremely important, especially in kind of creating this way for individuals to protect themselves, and that you don't want to create another Edward Snowden. It's by creating whistleblower protections, you're essentially creating not only the individual, but the country itself.
You hit a really key point there. And actually, the work that I was creating at DoD was in response to Bradley Manning, and then it really kicked off because of Edward Snowden. And so, one of the things that we did internally was look, particularly after Manning, was, in lieu of WikiLeaks, do we have a mechanism where somebody can disclose wrongdoing internally so that way it can be investigated and lawfully addressed? And that's where we realized that we had some issues there. And so there were mechanisms developed on the classified systems to enhance those capabilities, at least at DoD. And then to encourage lawful whistleblowing, we created the whistleblower protection programs that you now see. The problem is that even if Edward Snowden felt that there was something wrong, by going and publicly disclosing a ton of classified information publicly has now been weaponized by our adversaries and actually can do more harm by virtue of unlawfully engaging in such an unlawful disclosure than perhaps the underlying issues were. Of course, that's up for debate, but that's why we created the systems that we did, is to mitigate against that, to prevent that.
Yeah, the world was exposed to the word whistleblower in such a large way for one of the first times in 2020. Can you describe more what a whistleblower is exactly, and what the process looks like for U.S. governmental employees who become one?
Absolutely. So the word whistleblower is actually, it can be a divisive term, but it's also a term of legal art. It has meaning in the space that I operate. Okay, so and I tee this part of the conversation this way because previously, when members of the press, when reporters were using the word whistleblower, they were assigning that term to individuals who disclosed any wrongdoing in any way, shape, or form, or any suspected wrongdoing publicly. Okay. However, in order to qualify as a whistleblower under law and regulation, you have to disclose lawfully, because by being identified as a lawful whistleblower by a law, that means that you're entitled to protections. Okay. So the key thing here is to understand that when I use the term whistleblower, I'm thinking of somebody who properly went through the process to legally disclose the wrongdoing, so that, God forbid, should they be retaliated against for engaging in that protected activity, that there is a mechanism on the back end to investigate to see whether or not that is actually being done in retaliation. That's what this has accomplished. Okay. So that's kind of the key thing that I just wanted to flag about the term whistleblower. And, yes, over the past year or so, that term has been used quite a bit, in part because of my client, the individual who's, I call, people know him as the individual as the Ukraine whistleblower. I've always referred to him as the intelligence community whistleblower, but the individual who disclosed the concerns through the intelligence community inspector general, that resulted in eventually an impeachment inquiry and the impeachment of the president of the United States, the first impeachment.
Yeah, well, turning to that more specifically, can you tell us a little bit more about your connection to the case and what your role exactly was?
Yeah, so I was retained early on by this individual. This individual came through me, and this has now been it's out there publicly, referred to me by somebody who was formerly within the intelligence community because of my expertise in this area. And so I provided advice and counsel to this individual about how to go about filing the complaint. So I knew most of the issues and a lot of the facts right from the outset before the complaint was even filed. And just to make it clear, I did not write the complaint because of the gravity and the issues involved. I took an additional precautionary step, which is, even if something was not classified, I did not want to see it, write it, touch it. And so I provided advice and guidance to the client, knowing as much as I did, which was plenty, to get this complaint filed with the Intelligence Community Inspector General's office. And there's actually a mechanism in place that now everybody knows about, which is the urgent concern process, where if you believe that there is a significant issue involving an intelligence program or operation, that you can file an urgent concern complaint with either a CIA IG, DOD IG, Defense Department Inspector General's office, or the Intelligence Community Inspector General's office. And that triggers a 2-week review where they do what is effectively a preliminary investigation. Okay, it's not a full investigation, it's a preliminary investigation to see whether or not the allegations merit further investigation. But if it's deemed to be urgent and credible, okay, then this, by the Inspector General, then this is, then a notification is made to the Director of National Intelligence. And this complaint should then automatically, after that designation, be sent to the House and Senate Intelligence Committees. If an Inspector General does not find a complaint to be urgent and credible, by law, we can then request for guidance as to how to go about going to the Hill in disclosing these allegations directly. The reason for that is because if the information involves classified information, we want to coordinate with the executive branch as to how to go about providing that information to Congress, because Congress does not control classified information. It's actually the executive. It's actually the executive branch. So, but in this case, what was fascinating and troubling, frankly, was that the IG made a determination that the complaint was urgent and credible, and I knew that because the IG's office was in regular contact with the client and myself.
The Inspector General's office, that's an independent review process, right? That's not.
Correct. And actually what's really important, and I think just as we step back and think about this historically, IGs have existed for a long time within the federal bureaucracy. The first Inspector General was actually Baron von Steuben, who was the Inspector General under George Washington. He has actually a monument to him in Lafayette Square. But inspectors general were not created statutorily, meaning by federal law and by an act of Congress, until 1978. And you may wonder, well, what happened that in 1978, Congress and the president created this entire process of having an inspector general community basically conduct internal investigations and oversight operations of the departments within which they reside. And that is, this is part of the result of Watergate. Okay, one of the things that happened was, how do we ensure that the executive branch is able to monitor itself to ensure that no violations of law, rule, or regulation or anything untoward is occurring? And that's why you have the IGs created. And an important part about the independence and neutrality of an inspector general, which for some of them didn't exist until even as recently as 10 years ago, was that they have their own general counsel. So an IG, okay, is a component of the agency within which they reside. So let's say you have the Department of Defense, okay, big DOD. The Inspector General is a presidentially appointed, Senate confirmed individual. They have their own general counsel's office because they have the ability to conduct oversight over all of the DOD, okay? But their independence and neutrality, in my opinion, is truly underscored because they do not have to rely on the legal sufficiency of the department over which they reside, because that would be a clear conflict. So that's how the process was created. And in that time, from 1970 until today, it's taken years to create these oversight mechanisms within the federal government, and then to create mechanisms where people internally can disclose wrongdoing, i.e. whistleblowing, to, for example, the Inspector General. And then to build on top of that, again, creating mechanisms to protect whistleblowers. So what happened was, going back to the Ukraine case, when I learned that the IG had made a determination that the complaint was both urgent and credible, okay, and that it was basically going to be overruled, that there was by the acting director of national intelligence. I mean, literally, first of all, I couldn't frankly believe it, because it's never happened. Because it's not just that there was a concern that an investigation was not properly being pushed to Congress as it should have been, because again, the individual who had the authority to make this determination was Michael Atkinson, the IG. But now you have illegally the director of national intelligence or acting director saying, no, I disagree with your determination, which, by the way, they don't have by that law the authority to do. Okay. So the intelligence community, the director of national intelligence, did not have the authority to overrule Atkinson. And then somebody was pushing out to me that because somebody's taking the position that because we're not calling this an urgent concern disclosure, that may call into question the whistleblower protections of the individual, which that's not how it works. Okay. Even if you're mistaken by what you disclose, by virtue of making a disclosure, you in a protected manner, you obtain whistleblower protections. So two things are happening in that brief space of time that just shocked me. Was one, the independence and neutrality of the Inspector General was being was in jeopardy. And two, the protections and the systems in place to both encourage lawful whistleblowing and as well as protect those lawful whistleblowers was being completely undermined. So when you think about this, something that took years to develop, post-Watergate, was, in my mind, at that very moment collapsing. So I knew I had to do something. So with that information, which occurred on a Friday, I made a decision along with my one of my colleagues, Chuck McCullough, who's a partner with my firm, that the prudent course of action would be for me to draft a letter to Congress, to the House and Senate Intelligence Committees, notifying them of something very simple, which is that I represent a member of the intelligence community, a whistleblower, who filed a disclosure on such and such a date, that we understand that the Inspector General determined that the complaint is urgent and credible, and that this complaint is being blocked from going to the Hill, as required by federal law. Okay, so I reached out to some contacts that I have on the Hill, both in House and Senate, and on Monday, September 9th, I hand-delivered that letter to the intelligence committees. The Senate, the staff there were not particularly interested in meeting with me. This did not, when I gave them a heads up as to what this is, that did not pique their interest. But I did meet with members of the House intelligence staff, specifically 3 attorneys. Okay. And what I was able to do was articulate in a very broad manner what this is about. Okay. We have a complaint that was deemed to be both urgent and credible. It should be going to you guys, and it's not. When asked what this is about, what was strange about that day, among other things that you'll hear about in a moment, is that morning, the committee had actually initiated 3 investigations, one of which involved Ukraine. And so I said to one of the attorneys that I can't get into the details. I did suggest that it involved presidential communication. And I did say it may involve something that you just initiated, ironically, to look into today. And then when they said we initiated 3 things, and when they got to the Ukraine thing, I said, well, that could be the interesting one. Okay. As we were wrapping up the meeting, okay, there was a knock on the door, and one of the attorneys had left the room, and I continued just chatting with the 2 other attorneys, and then the gentleman comes back in, and he was, you can just tell that something happened, and he was just kind of just turned pale. He became ashen. He calls the other individuals over, and they look over this correspondence that he has, that this gentleman had in his hands. And then they say, Andrew, we just received a letter, correspondence via email from the Intelligence Community Inspector General telling us basically what you just told us, and things match up directly. So, and that just sent a chill down my spine, because this is me as counsel for the whistleblower coming to the Hill and saying, we have a problem, okay? And then you have the IG himself sending communications while I'm on the Hill saying, we have a problem. Because you have to understand, this is not just about the underlying issues that everybody was really interested in, presidential communications, everything that impeachment became about. But in my world, this is an issue of the system was literally collapsing. And we are, both I as private counsel and the IG were screaming, we have a problem. So what was surreal was, after that meeting, as I was driving home early that afternoon, it became very clear that something was going to be kicking off. That was made very clear to me. And probably no more than 10 people in all of DC at that moment knew what was going on. And it was just surreal. It was just surreal. What wound up happening was, it took a couple of days, but that following Friday is when Chairman Schiff posted on his website that they're looking at doing I think it was either they want to do subpoenas and do an evidence request for documents associated with this. But it was just posted on his website. I was given a heads up about it by somebody. who's been like monitoring stuff on the Hill, because that's what some of my colleagues do, because that's what they do. And so I was at dinner with my wife and my sister-in-law. My sister-in-law was getting ready to go overseas because she's with the American Red Cross, and she was getting ready to go to do some disaster relief in the Caribbean at the time. And I said, so as you're leaving, something may be kicking off while you're out of town. That's all I can say. I think something's happening. And then clearly things were developing behind the scenes here in Washington because people noticed what was posted. And I've learned since in conversations with members of the press, things were really spinning up pretty quickly behind the scenes, people just trying to figure out what was going on. And it wasn't until Sunday afternoon in one of the morning shows that somebody brought it up, and then Monday it kicked off. And then on Wednesday, if I recall correctly, either Tuesday or Wednesday, I was identified as the attorney for the whistleblower. And that kind of rocks your world, because at that moment, literally every member of the media contacts you.
Yeah. I mean, it was such hot news at the time. It's incredible how the whistleblower's identity was managed to be maintained anonymous. Can you see the pressure of what that was like, and how you managed your communication strategy?
It was intense. It was intense. So what happened was, phase one effectively was, we wanted to get the goal was always to get the complaint to Congress, because this involved the President of the United States. The only proper place for this to go to is outside the executive branch into the legislative branch. And so let me just finish on phase one really quick, which is that following week we had to try, there's still this block. It's not getting to the Hill. The complaint's not getting to the Hill. But because I've been identified publicly as counsel, I brought on Mark Zeta as my co-counsel to assist me with the case. And then, the last thing that we did was we sent a letter to the Hill saying, remember when I said before, if it's not deemed to be urgent and credible, we can ask for guidance, that we want to go to the Hill and make a disclosure. We just said, we're going to the Hill. Tell us how to go about doing this. 48 hours after that, because of other intervening events as well, the complaint was sent to the Hill. I believe the White House issued the transcript of the phone call, and that all happened the morning that Acting Director McGuire testified at the Hill. So that was our goal, was solely help the client, help them when they see something, say something, file it lawfully. This should go to the Hill. And now all efforts turn to what Maria just highlighted, which is now protect the client. And that took a lot of effort, okay? Because there were a lot of pressures from members of the media to speculate as to who the individual would be. I was receiving phone calls where people were trying to identify names to me. And I actually became very curt with one individual on the phone, where without getting to detail, cookies arrived from this network as an apology, because I really had to stand the ground of, you cannot know who this is. That undercuts the purpose of encouraging people to disclose wrongdoing when they see it. Okay, that's how the system is set up if you want anonymity. And in this case, the client wanted anonymity. They were going to be the vehicle by which the information gets to where it needs to go, and then it needs to get sorted out, by investigators and gather the evidence, gather the documents, talk to people. Okay, so we did a lot of things behind the scenes, whether it was pressuring both the legal arguments as well as public policy arguments to members of the media, to legislators, to just a lot of people to make it clear that we cannot have our clients' identity disclosed. And as far as I'm concerned, we succeeded, because when you have no mainstream news media outlet even attempting to disclose an identity, And then when a member of the United States Senate attempts to do something like that, that the Chief Justice of the United States says no, that was just a good feeling that day, knowing that we were able to prevail in that regard, because that became paramount. So everything from protecting their identity to ensuring that we did what we could to ensure their physical protection was important. So my work was not just, the practice of law. It was also engaging in messaging strategies. It was engaging in ensuring that we had protection for, or whatever mechanisms we needed to have for various individuals who were either on the team or otherwise. And, by virtue of being the face of that, we had to ourselves, deal with death threats and up-arming ourselves and taking appropriate actions. The key thing that just comes to mind when you were asking, though, about, one of the rules that I instituted when handling this case at that juncture is that I never, you probably recall, you probably never seen me on TV discussing things about this case, and that was intentional. I did not, unless necessary, I was ready to if necessary. We did not want to go out there publicly and become an overly public face of the situation either, because we did not want to draw attention to ourselves and our client. Whenever we did communicate in a formal manner publicly, or even informally by Twitter, we did not do it by using the president's name. I refused to enter that arena because nothing was going to be gained by that. So as far as I was concerned, when the president of the United States was either directly attacking my client, my co-counsel, or me publicly, I'm just not going to engage directly on that. There's no need. So there were certain rules that I set out right from the outset that we followed to the end to ensure that we didn't get sucked into something that is just unimaginable. As I told a number of individuals, I said, we're not getting sucked into the gutters. I'm not playing in the gutters. And because we kept it professional, and because we did what we had to do to protect our client, I believe that is why we were successful in what we were able and what we needed to accomplish.
Yeah, I can totally relate to the less is more, what you were saying earlier. As a law student, I've learned sometimes less is more. Sometimes all you want to do is say yes or no when you're answering your professor's question.
Correct.
It's a little
Correct.
bit that way.
Correct.
So moving on, why, as you look forward, what kind of changes are you hoping will come for a greater protection to whistleblowers?
Yeah, there are two things that come to mind. The first thing is that the protections for whistleblowers, at least under most rules and regulations and laws that I can think of, apply to the individual. But in instances where I'm representing clients who have security clearances or members of the intelligence community, I get read in on matters as a matter of course. And I've now only recently been also re-adjudicated for security clearance to work on a number of matters across the government. So a concern that I would have is to ensure that the attorneys are not, for a particular whistleblower, aren't being targeted either, to try and to diminish our ability to represent our client, which is actually important because attorneys such as myself, my colleague Chuck or Mark, and also through an organization I work with, Whistleblower Aid, the thing that we do is we also make sure that the clients do things the right way, which is also, that's to everybody's benefit. We're not trying to play games here. We're trying to do things the right way. But there is a concern that there can be, in the future, somebody trying to manipulate a situation where it adversely impacts our representation of a client. Another thing that does come to mind, just from personal experience, having worked within CIA and then myself having to assist whistleblowers within my office, is that there is a weakness in the system as it comes to protecting Inspector General whistleblowers. So then the question becomes, how do you protect the watchdogs So it's and that's a challenge right now, because I myself had engaged in protected activity. And and then I look at some of the colleagues who I now represent who are also Inspector General individuals. Where do you turn to? Where do you file your complaint? Who do you address your concerns with? So the system as it was developed and as it was built think of it as a foundation. I think that it has yet to mature. I'm helping it mature as outside counsel now, given the case that I'm pushing. But there are still vulnerabilities out there. There are some holes in the system that need to be addressed. And I do believe that over time they will be. And hopefully, given our work on the Ukraine matter, people understand the importance of having our civil servants have a mechanism to disclose things in the manner that they should, and also be protected for doing so. A lot of the disclosures involve, financial fraud issues. That goes to the heart of taxpayer money. That's what a lot of whistleblowers disclose. There is a benefit to people coming forward when they see something or believe they see something wrong.
It definitely seems like a bipartisan issue that both sides of the aisle would want to work together on to protect both citizens and employees, because one day they themselves could become a whistleblower. You never really know, I guess.
Absolutely. And typically it is a bipartisan issue, because most of the time the issues that we handle aren't political in the sense of the bigger political issues that you see here in Washington. And they may be political from the standpoint of internal office politics or agency versus agency, but they're apolitical in the sense of, Democrats and Republicans, for example, don't want Americans to be spied on, right? Yeah. I've had either cases either when I was with the government or in the private sector. I'm going to leave it vague there, but where I've worked on matters where there was the allegations of improper intelligence operations, or 12333 violations, which means that the unlawful monitoring of American citizens. These are significant issues. You may not hear them day in and day out publicly, but they are getting addressed internally. But in order for them to get addressed internally, somebody has to come forward and say, there's a problem there.
Yeah.
And that's why we have the system that we've developed.
Yeah.
Again, there's work that has to still be done, but it's a start.
It's glad to hear that you've got a good framework or a good foundation to work off of. So we have a number of students on the line, law students and undergraduates from GW, and GW is a huge feeder school for federal positions. Do you have any advice that you'd like to share for somebody who is looking to go into federal work?
Yeah, I mean, the first thing is that some of my fondest memories professionally have been when I was with the federal government, and even now in private practice. Most of my clients are federal employees. So I will say that if you want to go and serve the nation, engage in public service, it's a wonderful thing to do. It's fun. It's fun. It's interesting, and you have impact. Okay. The one thing that I would say is that, especially if you're a law student, a lot of times law students are always looking at, I have to start working immediately in the general counsel's office or as a legal advisor or whatnot. That wasn't my road. I actually started working as an investigator within DODIG. And so sometimes, there are interesting positions out there that aren't necessarily, as a lawyer, but are a different type of position that can also lead you to working in the general counsel's office and doing something else and start bouncing around and having a really good flavor and idea in terms of all the different things that can exist or occur within a particular department or agency. So don't feel constrained. Feel free to explore. And it's a lot of fun. And I have seen colleagues who are many years my senior who have gone from, being a JAG in the Air Force to head of investigations within a Defense Department component, to then being a general counsel in that Defense Department component, overseeing those investigations and going back, because you can. And so that's something that I would say that as you're looking to start your federal career, don't feel limited. There are a lot of opportunities out there. And then the other thing that I would say and this is based on advice that was provided to me when I was transitioning from the government to the private sector, starting my own firm and working with my colleague, Mark. One of my good friends, Todd Plotkin, actually, he's an alumnus of George Washington University as well. He said, you should read this book. And the title escapes me, but it was written by the authors of, or the founders of LinkedIn. And the idea is basically, treat every portion of your career as a tour of service, which resonated with me because even though I didn't serve in the military, I did serve at the Defense Department. And so the idea is, unlike years ago when you would say, for example, start working at IBM or whatever, and you'll be there for life. Now the experience is that people go from one position in one company or organization and then transition to something different. But in all of those interactions, you will meet people and make connections that maybe you don't see it at that moment, but 5 or 10 years from then, you may be working together at another job or in another capacity. And that's very true for myself. I mean, people, you always hear when you start college, look at the person to the left and right of you and in front and behind you. One day you're going to be, doing something together. That actually wound up being true for me. And so, 5, 10, 15 years later, all of a sudden, somebody who I sat with in class or somebody who I used to work for, we're now either working together as a team. And oh, by the way, my mentor is now a colleague of mine. So, the important thing is that I would say is, in a nutshell, don't burn bridges, okay? And keep your eyes open, because you never know what opportunities will present themselves during the course of your career. And you never know when a connection from years ago will be reconnected to you years later, and you'll be working together in some capacity.
Yeah, I think that's great advice. So I'm going to prompt the guests that if you have any questions, please feel free to put them in the Q&A tool. We've had a few come in, so I'm going to start asking some of our guest questions. Our first prompt is from Beth Tarini, a student in the business school, and she asks, can you talk about retaliation? If an individual is blackballed by the sector in which they work, is that considered retaliation? And what other forms do retaliation take?
Yeah, so the definition of retaliation is really specific in a federal context. So in order for you to file a complaint of whistleblower reprisal, another word for retaliation, you have to have an adverse action taken against you. That is an adverse personnel action or a security clearance action. Suspension, demotion, significant change in duties, responsibilities, or working conditions, having your security clearance suspended or revoked. So those are things that then qualify or trigger a reason for an investigation or litigation as part of an allegation, say that I'm being retaliated against through these mechanisms because of my protected communications. Being blackballed is a lot more amorphous. I would have to know more facts to know whether or not that would hit one of the legal requirements or the legal requirements or definitions that identify this is a triggering mechanism to investigate for retaliation. Now, if, for example, somebody's being denied a job in reprisal for their prior protected communication, that can happen. I mean, if you disclose wrongdoing about an official, and then that person contacts a prospective employer and tanks your candidacy, there may be something there. So again, a lot of this is fact specific, but it has to still fall into one of the employment categories, because effectively that's employment law. And then we transition to the national security sphere when we're talking about security clearances in the intelligence community.
We have another question. You touched briefly on this, but where does a whistleblower go when the Inspector General and or the Office of Special Counsel is part of the problem or ethical legal violation?
So we actually, that's not, that has been an issue that I've experienced in a case or two that I've handled, where I had a concern about the independence and neutrality of an inspector general, or maybe my confidence in their abilities to do something. Okay. I'll use an intelligence community example for this, because that's where this example actually derives from. there was one specific intelligence community in IG that I had some concerns about their ability to handle a particular case. So instead of going there, I went to the intelligence community inspector general instead of another 3-letter agency. So I had a mechanism to file a complaint with another office. If the IG is a problem, I would then look for other mechanisms by which to make the disclosure. So, and it also depends where the individual works. I mean, if we're talking about somebody who works, for example, in the Department of Education, or education is a clear example, or the Park Service. I'm using these 2 examples because they really they don't do classified matters for the most part, right? There may be a component that does, but for the most part, they don't. So they may not be constrained by, for example, going to the press or going directly to the Hill, okay, to make a disclosure. There may be mechanisms in place. For members of the intelligence community, you can't do that. You can't talk to the press, and you have to get authorization and lawfully go to the Hill. You can't just go to an intelligence committee and make a disclosure, because even though it's an intelligence committee, they may not be read in on the specific program or operation you're getting ready to disclose about, which becomes a security issue, security violation, or mishandling classified information issue. So there are other mechanisms in place. So it may not be a great answer that I'm providing, but I would try and find alternative mechanisms by which to make the disclosure. And those mechanisms, which mechanisms I would use, what would drive that train is who the individual is working for, what the information they're looking to disclose, and then I would try and see what options I can create. These are things that I do regularly, but it's very fact specific. And then we have to do a risk analysis as well to determine whether a particular course of action is prudent.
So the next question is from law school alumnus Alexander Kish. In what way are whistleblower protections in the intelligence community different than those established by 5 USC 2302B for non-intel community federal employees? Is the process similar?
It's different. So first of all, if you're a non-intel, if you're a member of the federal bureaucracy and you believe that you've been retaliated against, and you go to the special counsel's office, and then you make it to the Merit Citizens Protection Board, you have at least a quasi-judicial body to have a hearing and go through and figure out exactly what transpired. And I know there are criticisms about that process, but at least there is a process that is totally outside of the agency, for what it's worth. And I also do know that because the Merit Citizens Protection Board, MSPB's board, has not been in place for many years, there is a backlog, but the admin judges are still functioning. So you still do have that route. So that's one key distinction, is that all of the federal employees have that mechanism. Okay, they can go to that quasi-judicial body. If you're in the intelligence community, your only avenue of recourse is under Presidential Policy Directive 19, and that is within the Office of Inspector General. Okay, and as it's written today, you have to file that complaint initially with your Inspector General. So if you're at CIA, you have to file a CIA. If you're at Defense Intelligence Agency, I typically take it to DODIG first because they're a defense intelligence component, but then it typically gets sent over to DIA, okay, which is fine. But so that's a key difference, is that you have investigators conducting the fact finding, and there is no quasi-judicial mechanism by which to litigate this, okay, which is why I try and flood the record with as much information as I can, so that way the investigator not only understands the facts as I'm presenting it to them, but also the legal framework. Because, I think a lot of agencies are getting better at this, but this is still fairly new. Okay. So process-wise, that's a big difference. And then the other difference is that you have under 5 U.S., you have the standards and burdens of proof listed out under Presidential Policy Directive 19 for under Part A, which pertains to adverse personnel actions. They're encouraged to use Title V as a model. It's not a requirement. They're encouraged to fold it in as much as they could. And then when it comes to security clearance actions, the burden is actually lower for the agency to prevail. I can go into more detail, but it's a bit technical. but hopefully those distinctions help the person who asked that question understand that there is a difference. There is a difference.
So you talked a little bit about what happens if, I mean, that a whistleblower, even if their information is incorrect or they were mistaken, they're still afforded protection. But what happens if, have you ever represented somebody who turned out to be not credible, and they're trying to hurt another person by sharing information? What happens in that instance?
Well, first of all, I vet my clients before I take them. That's what all attorneys do, and I do that as well to see whether or not there's something there. Because before I proceed, I want to make sure that at least I have a basis to move on something. Okay. The question that's basically prompting is misuse of the system, and that can happen in any system, and that certainly can happen. Typically, when questionable allegations are filed, or it's something that's really specious in some way, shape, or form, you can tell during the intake phase within the IG's offices whether or not there's reason to proceed. Okay. On the flip side, individuals who intentionally fabricate evidence to the IG, for example, to trigger an investigation, they can actually be held accountable for doing that. So yes, it is a concern. I have myself have not seen much of that on my end. Doesn't mean that it doesn't happen. And also one thing that I'll flag is that two things. One, while I conducted investigations and oversight operations within the federal government previously, I was acting as a member of the IG's office, working on those cases, creating the programs and operations, et cetera. It's the hotlines that do the initial intakes and try and assess how to handle the situation. So if something is, doesn't rise to a particular level, it usually gets triaged at a hotline. So I've never had to deal with that. The other thing is on my end, when I, in private practice, a lot of my clients are referrals. So they come in with at least some sort of credibility assessment that I can kind of gather, okay, I can talk to this person, but, I still have to triage it, just like anything. And even with my good cases, I've got some great cases right now where I have to ask some probing questions, because I want to make sure that when we step out of the gate, that I'm ready to go, that I have something that I can stand on and move on. Because I as counsel, and it can happen to anybody, but I as counsel do not want to all of a sudden draft something and then within 30 seconds there's just nothing there. So I do an assessment.
I think we have one more technical question for you. The next question comes from Irvin McCulloch at the Government Accountability Project.
Hello, Irvin.
How could Congress better protect intelligence whistleblowers' confidentiality?
First of all, great question. Second of all, they need to expand protections that the confidentiality that does not just end with the Inspector General. So by law, if you request anonymity and have your identity protected, that only applies to the Inspector General's office. It does not apply to anybody else. But I think that the Congress does need to consider expanding the confidentiality rules, at least to other components or other elements of the executive branch, okay? And maybe even beyond, but at least start there. If you file a complaint with DOD IG and you're asking for anonymity, right, or confidentiality of your identity, and then during the course of the disclosure being handed off to maybe another component or somebody else, that somebody else in another component of DOD identifies who the whistleblower is, they should also be required to maintain that confidentiality. I believe that the Ukraine case really highlighted some concerns there, and so I do believe that they need to consider legislation to expand where the protections rest, okay, where that anonymity needs to be protected.
So it seems like you've got a lot on your plate all the time. Do you ever have any time for fun? What do you do for your hobbies?
So aside from going to bed at 2 a.m. or 2:30 like last night, which is becoming a regular thing, so I like to golf when I can. Cycling a lot. I used to run a lot. So I used to cycle. So cycling, running, golf when I get the time, but that's becoming harder because I just can't just peel off for a couple of hours necessarily anymore.
Yeah,
But
golf
yeah,
is time consuming. Well,
it
the
can
weather's
be.
so nice these days. I hope you get outside to be able to do some of those things.
I've been trying to for the past 2 Fridays, and last Friday and the Friday before, and I had emergency situations come up, so I had to scrap everything. It's life.
Yes, the life of an attorney. Well, thank you so much for taking your time to speak with us today. I'm going to turn it back to Matt Donovan for some closing remarks, but thank you so much.
Thank you.
Well, thank you both. That's a fascinating discussion, and so different from what we typically get to discuss at the Elliott School and within the GW community. So I'm grateful to you, Andrew, for sharing your time and your expertise, and for your dedication to the work that you do, as it's so important. And to Maria for navigating a conversation on a topic that scares myself and many other people. So I'm grateful to you for taking the reins on this one. And just before we close, I also want to thank the Elliott School's Leadership, Ethics, and Practice Initiative and Chris Kojum, as well as the GW Law School, who shared this event with their communities. We will have a recording available afterwards, so you will get a chance to revisit the conversation if need be. And then I also want to put the save the date out there for an event that follows this, but is a nice segue, which is hosted by the GW Alumni Association and talks about GW's role in public service. So that event is going to take place on April 15th and will feature Elliott alumna Senator Tammy Duckworth, his fellow alumna Nadia West, who is a former U.S. Army Surgeon General, as well as Rosalind Brock, who is a GW alum and Chairman Emeritus of the NAACP. So more information on all of that, but for now, this concludes our program. Thank you to both of our panelists again for joining us. This was really, really fascinating. And Andrew, hopefully you can hit the golf course this weekend.
One day.
Great.